So today I'm indeed happy to have a very good panel today.
I can't hear you. I can't hear you.
Am I audible now?
Yes. Now you can audible. Yes.
Am I audible to all panelists?
Yes.
Okay. So, hello and welcome to a Legally Speaking special webinar series. And I'm happy to welcome a very distinguished panel today. We have got Justice Iqbal Ahmed Ansari. He's the former Chief Justice of the Patna High Court and as well as currently the Chairman of Punjab Human Rights Commission. We also have Senior Advocate KK Manan with us, joining us on Zoom today. He is a distinguished name at the bar and indeed has thousands of followers, as we can see from his earlier speeches, the kind of people and the number of people who want to watch what he says and understand what he says. We've got Advocate Aman Hingorani, who obviously is also a good friend and has been participated in Legally Speaking many times and is also a published author, having published a book called Untying the Kashmir Knot, which I had the opportunity to interview him with Justice Ahmadi, our former Chief Justice of India. So he can also share a lot of perspective on human rights from that angle, since he's written extensively on it. And of course, Rubinder Ghumman, he's helped put this up. I would also like to welcome him as and when he joins. So what we'll do is I'll share the format with you. Since on Zoom, we cannot have an active discussion because it is very difficult to do so. We will give 15 to 18 minutes time to each of the panelists to make his point, and then we'll move to our question and answers. So we first start with Senior Advocate KK Manan. In about 18 minutes, he'll share his views with us, followed by Aman Hingorani, who will do so. Dr. Aman Hingorani will share, and then finally Justice Iqbal Ahmed Ansari would conclude it. If Robbie comes in between, he will speak for about 5 to 6 minutes on this issue. So may I request...
Sir, Robbie sir is already here, sir. He's here between us.
Robbie is already in. So,
yes,
so what we'll request is, Robbie, can you initiate the discussion on human rights in about 5 or 6 minutes, and then we can request Senior Advocate KK Manan to give his 18-minute speech with us or share his points with us.
Sure. Hi, Tarun. Am I audible?
Yeah, you are audible to us.
Right. Can I start?
Yes.
Hello, everybody. Good evening to you all. Today's topic is human rights. Broadly, human right can be defined as right inherent to all human beings, regardless of their nationality, ethnic or origin, religion, language, location, color, age, gender, and status. Human rights are usually universally applicable, inalienable, and are same for all everywhere. Hence, it is expected of every person to respect human rights of others. Human rights cannot be denied except in certain extreme circumstances, that too after following the due process of law. With advancement in civilization, the meaning of human rights has evolved and manifested as free speech and expression, right to dissent, and civil rights, and form the very fulcrum of a democracy. Post-industrialization and economic progress, human rights are also synonymous with a decent standard of living, education and employment, opportunities, social security, and right to medical cover, better living conditions, having clean air and water, etc. International human rights law promotes human rights through regional and domestic instruments by contributing towards understanding, development, and implementation of human rights laws amongst member nations. Raised by the effect of Second World War and events of Holocaust, the international community resolved to work conjointly towards world peace and development. Accordingly, Universal Declaration of Human Rights was made on 10/12/1948 by UN General Assembly. The declaration charter consists of 30 articles recognizing various natural laws such as right to quality, right to life, and liberty, freedom from discrimination, slavery, torture, and disregarding treatment, freedom, treatment, etc. UN Universal Declaration on Human Rights, together with international Bill and Human Rights Charter, recognizes that human rights must be protected by the rule of law under the municipal or international law, as the case may be. Members nations have a common understanding of human rights as a set out above said charters and covenants regarding pledging to universally protect the human rights of all people, of all the people of all nations, which makes it incumbent upon the member states to act in certain way and to refrain from certain acts to provide and protect human rights of individuals and groups. Despite the well-founded mechanism and code of international law, furthered by the municipal mechanism of to safeguard the human rights of every individual, the world continues to face challenges, as there have been glaring instances of commission of brutal crimes. For instance, the Nigerian government has been routinely under scanner for human rights violation of individuals and groups involved in insurgent activities. The countermeasures include gross human rights violation against those associated with the insurgent groups, including acts of heavy measure of Boko Haram, who is killing over 6,600 in 2014. They carried out mass abduction, including killing of 276 schoolgirls whom they abuse. Similarly, Iran has a history of human rights violation. The government of Iran is criticized by the United Nations General Assembly and Human Rights Commission, both for restrictions and punishments that follow Islamic Republic Constitution and law, and for actions such as torture, rape, and killing of political prisoners, and beating and killing of dissidents and other civilians. Restrictions and punishment in the Islamic Republic of Iran, which violates international human rights norms, include harsh penalties for crime, punishment of victim lists, crimes such as fornication and homosexuality, execution of offenders under 18 years of age, restrictions on freedom of speech and the press, including the imprisonment of journalists and political cartoonists, and restriction on freedom of religion and gender equality in Islamic republics. Constitution. Stand of human rights can be variable and relative to the system of government and context. In age of internet and connectivity, every crime relating to human rights violation gets to be widely reported globally, setting into motion the international human rights to mechanism to restore the human rights and dignity of affected parties. Now, coming on to the Indian human rights, the courts have played a very active role. Now, let's take a right to bail. Right to bail is a human right which is a fundamental right in nature, which is provided under Article 21 of the Constitution. Right to live with dignity, right to shelter, right to file cases, right to move freely, right to, there are civil laws such as municipal laws, which all are part of human rights, which India is a signatory to and has signed various treaties and declarations. Now, one of the recent cases of the Honorable Supreme Court in Shriya Singhal, where the Honorable Supreme Court struck down the provision of IT Act, saying it unconstitutional, that the freedom of speech is a fundamental right. Again, talking about international case which is glaring, which has glared the whole nation internationally, which has rocked the world, that was the Jadav's case. Now, Pakistan was executing an Indian charged of spying and with a death penalty. India rushed to, I think there's someone on the screen. I can't see anyone. Tarun, I can't see anyone in this. Am I audible?
You are audible. You are
Yes.
audible.
Yes, sir.
I
You are
can't see
audible.
any.
You are audible
Right.
to us.
Now, in Jadav's case, it's a beautiful case where one of the senior leading lawyers and one of the stalwarts of our institution, Mr. Harish Salve, he went and said that before the International Court of Justice, the result of which we all know, that consular access was not provided to Jadav. And this was in contravention of Article 36 of the Geneva of the convention, Vienna Convention. The matter was heard for 2 days, and ultimately we all know the results. The result was that Jadav's consular access was accepted by Pakistan, and the ruling given by the military court was set aside, and which has been put on hold. Now, it's even if during the lockdown period, if you look, it's really sad that I was just reading the newspaper in which around 15-20 migrant workers who were sleeping got crashed down by under the rail. Now the question over here is that state comes under Article 12 of the Constitution of India. Now, the state is duty bound to respect the human rights and values of every individual, irrespective of any caste, creed, religion, or status. Now, equally, do the people have the same rights who are not well-to-do off? And I guess during COVID period, though the government is doing a lot, much needs to be done. Now, while ending up the topic, short topic in front of my stalwarts, but I throw up a question to Aman Hingorani sir and KK Manan sir, one by one. So, you all are very well prepared with your topic. Would I, in the end, request you just to throw a light, Aman Hingorani sir, on Kashmir issue, and KK Manan sir, that every young lawyer has a right to dignity under Article 21 and right to encouragement and all that. And what is the BCD doing for these for the encouragement of and social security of these young lawyers? Would I request you to please answer this question in the end, since you are the BCD sitting member and chairman of BCD. Thanking you with this. Over to Tarun, since I had a very short time. It's a very lengthy topic. Thank you so much, Tarun. Over to you.
Okay, now may I request Senior Advocate KK Manan to share the information as well as his speech with us. I would also request everyone to switch off their microphones so there is no disturbance, and a lot of people who want to take notes as he speaks are comfortably able to even take down their notes. So may I request Senior Advocate KK Manan to please address the gathering.
Good evening to everybody. I'm coming for the third time, and you know very well that I don't belong to that category, that I'm constitutional expert lawyer. Started from trial court, though practicing in the High Court, Supreme Court as well. I will leave main things so far as human rights and Constitution of India is concerned to Justice Ansari and my neighbor, because you have taken two panelists from Niti Bagh, one my younger brother, Mr. Hingorani also. He will also elaborate much about the Constitution and human rights. I will have three topics today. One is sexual orientation and gender identity. Second is bride buying in India and children's right. And so far as human rights are concerned, so many rights are there under Article 14, 19, 21. I will leave all these articles to my learned other panelists. First of all, I will take the issue of sexual orientation and gender identity. You know, first of all, that Delhi High Court has struck down the section 377 of Indian Penal Code, which was subsequently upheld by the Honorable Supreme Court in September. And that section was discrimination, consensual adult same-sex relations. The ruling followed decades of struggle by activists, lawyers, and members of LGBT communities. The court's decision also has significance internationally, as the Indian law served as a template for similar laws throughout much of the former British Empire. In December, the lower House of Parliament passed the Transgender Persons Protection of Rights Bill in 2018. Rights group and parliamentary committee had criticized an earlier version of the bill for contradicting several provisions laid down in a judgment of the Honorable Supreme Court, which was passed in 2016. Although the government incorporated several amendments in the revised bill, it failed to adequately protect the community, including transgender people's right to self-identity. My, in fact, view was a little bit different, but I bow my head. Whatever the judgment was passed by the Honorable High Court, as well as then confirmed by the Honorable Supreme Court. Now the law is also there. So I bow my head. Another, which is a very worrisome thing in this country, that is bride wine. We also say molki brides. Molki brides means one who is bought, or we also say paru. From the far side, in a bride wine phenomena, where the brides are sold by parents in the impoverished states of India to the husband in relatively richer states, who due to the skewed sex ratio and other socio-economic disadvantages, rather I will say, find it harder to find a bride within their community and region. Major destination states are Haryana, Punjab, Rajasthan, Western Uttar Pradesh. Though newspaper and the TV doesn't carry such type of stories, hard reality is this, which I am speaking today. I have little bit knowledge. I have knowledge, but vast knowledge about this. Number of cases came in my knowledge. The major source states are the improvised parts of northern East India, that is Assam, Bihar, Jharkhand, Odisha, West Bengal, Andhra Pradesh, and Tamil Nadu. According to the research sponsored by the Royal Norwegian Embassy at Delhi, the Molki brides are arranged for marriage in 4 ways. Molki brides as marriage mediators, husbands of Molki brides arranging brides for family and friends, marriage brokers, and trafficking of women for forced marriages. Though it is not as extensive and rampant, Molki brides face social and color discrimination, racism, slur, social isolation, and mental health issues. Among Molki brides, cases of those who are trafficking are rarely being published, either by print media or by the TV channels. If you remember that the Gulf countries sheikh or not so wealthy sheikhs, but mediocre sheikhs used to come. And in Andhra Pradesh, especially in Hyderabad, I did one case where a man of about 70 years came in Hyderabad, married a child aged about 16 years. You see the age gap, and the parents had sold, in fact, that girl through travel agents. Earlier, likewise in Punjab, was being looted by these travel agents by sending the people, alluring the people to send them abroad. Likewise, there was also, I will use a word, though it's a derogatory, but I will definitely use it. I don't shy. It's a danda run by travel agents to send people abroad, as well as minor children, minor girls from poor families, especially from Hyderabad and Andhra, Jharkhand and Bengal. So these cases sometime come in the picture, and sometime the TV people, TV anchors or the TV owners run such type of stories. This is an evil in the society, and in this lockdown period we have seen the real India. While people are being killed under the trains, you have seen the people going on the roads. How many people, not lakhs, crores of people have left for their destination, because though the government has announced that every employer will pay the salary, but virtually nobody looked after any employee, and this is in fact agony which is not being seen by the government, any state government or by the central government. I'm sorry to say, they are giving long speeches, long bhashan and long sermons. We are feeding such and such lakhs people per day. These are all the stories in the media. But at the same time, media is also showing how the people are going on foot, on rickshaw, on three-wheelers. Last night I was watching the TV, and people have started from Bombay to Patna by road, by three-wheeler. You can see. And you have also seen, first of all, I don't shy, I don't afraid. If Nitish wants to take action against me, let him take. Initially, Nitish Kumar said that he will not pay any tickets, fare for railway. So if the people comes to Bihar. Subsequently, though I don't belong to any political party, when one particular party had said that they will bear the fare of the people of railway fare, thereafter every state chief minister started saying they will pay, they will make the payments. In spite of that, people have shown the tickets. They bought the tickets, and not only bought the tickets, tickets were bought by them at a higher price. This is inhuman. Here is the human rights. What to talk about Syria? Everybody knows that Syria, not 100, not 1,000s, lakhs of male, female, small children have been killed there. Before that, what we have seen in Iraq, Iraq has been ruined by a particular country just to sell their weapons. I will call that country, particular country, it's a dada of the world. This country is a dada, and playing dadagiri with every country. Now, its head is also playing with China. Let us see what that dada will do, because China is also not a small country and small power. Anyway, now I'm coming on the third topic which I had, because I have written 3 topics today as Mr. Robbie ji and his team has directed me. So I am speaking today on this topic, though it is not my, in fact, sphere. My sphere was and is, everybody knows, I'm a basically criminal practicing lawyer, started from the trial court. Now I can, trial court lawyer can argue till Supreme Court, but Supreme Court lawyer cannot cross-examine in trial court, that I know. And now the third point was of a children's right. Children's rights, you have seen the latest 2 cases. In April, the government passed an ordinance introducing capital punishment for those convicted of raping a girl under 12 years of age. The new ordinance also increased minimum punishment for rape of girls and women. The ordinance was a response to the widespread criticism and protest after 2 prominent cases. In one, some leaders and supporters of the ruling party defended alleged Hindu perpetrators of the abduction, ill treatment, rape and murder of an 8-year-old Muslim child in Jammu and Kashmir state. The second was in Uttar Pradesh state, where authorities not only failed to arrest a BJP legislator accused of raping a 17-year-old girl, but also allegedly beat her father to death in police custody, and the lawyer of that family was also attacked. Ultimately, that case was transferred with the intervention of the Honorable Supreme Court to Delhi. Now that person has also been convicted by Delhi court. So the ordinance was widely criticized by rights groups. However, in August, with the Parliament's approval, the ordinance became law. Child labor, child trafficking, and poor access to education for children from socially and economically marginalized communities remained serious concern throughout India. I belong to a village. I know how the children goes to school in villages even today. Though we have progressed a lot for the last 73 years, but still we have to do a lot. Unfortunately, in this country, unfortunately, not all, I'm again saying not all, but some of the politicians have looted this country. Few families of political parties have looted the country. They have not created any infrastructure. They have not done anything for the others. They have done everything for themselves or for their relatives. We can see in Bihar, UP, we can see in Punjab, Haryana, we can see in Madhya Pradesh, we can see in Andhra Pradesh, we can see in Karnataka, we can see in Maharashtra. I can name every state even almost, except a few. It is unfortunate. But at the same time, we are very fortunate with the democracy. We are really fortunate that we born in this country and misusing the democracy. We want everything. We have every right. We don't have any duty towards the society. This is the country where you can abuse anybody without any reason, whether you know him or not know. But without knowing him, you can abuse him unnecessarily. This is the country where we have born. Please go to North Korea. So we are so fortunate. I have one video clipping where a child is crying for her mother and for herself, how she is explaining and elaborating the life in North Korea. In North Korea, nobody can see the film, nobody can see the TV, nobody can do anything except food. Sometimes they don't have to eat food also. You have seen how that king killed his own uncle and brother. So democracy in India, the constitution in India, though we have borrowed lot of articles from British constitution. You go to England, you will find in every city, Punjab person will be available. In every city, you will find Pakistani will be available there. From all over the world, the person will be available there. So I also admire the constitution of British. Simultaneously, I can't forget that our constitution is the supreme for me. Our Supreme Court is the supreme for me, our judiciary, the best judiciary of the world. But somehow, somewhere, it may be contemptuous today. Our honorable Supreme Court judges, High Court judges are also forgetting. Sometime they should give an indulgence for a few things, which they don't do it. I do not, why they don't, whether the constitution will prevent them or they themselves do not do. But anyway, still our judiciary is the best judiciary in the world. I will say because it's my 40-year experience from trial court to Supreme Court, seen a lot of things in the trial court, High Court and the Supreme Court. But at the same time, again I will request through this group, this free of cost, though I am going out of the way of the topic. From one pocket, you are taking it and putting it in another pocket who doesn't do anything. I work from since morning till midnight, earn the money. When my father was a farmer and he was not earning so much, he spent so much money on me, became a lawyer, I started earning handsome, now income tax payee, and my income tax is being shared by whom? Free of cost being delivered to the people? No, it is not the purpose to have the income tax. Purpose was to create the infrastructure. Now, in this Abda, in this crisis of lockdown or the disease, COVID-19, we are missing hospitals. If the country's government, central government, state governments would have constructed good hospitals, our doctors used to go, good doctors to abroad, they should have not gone. Our India is sufficient. So, with these words, I will say thank you. I hope that whatever I said, I have said it from my core of heart. Maybe a little bit contemptuous. I will say sorry for that, apologize for that. But sometimes man speaks from his heart.
So I would like to thank Senior Advocate K.K. Manan for sharing his thoughts with us. Now, since we are already at about 6:45 p.m., we have about half an hour to go. This is a 75-minute session. So may I request, without wasting any time, Dr. Aman Hingorani to share his thoughts in about 15 minutes or so. And then we go out to Justice Ansari, who will give his share his thoughts, and then we can have one or two questions. May I request Dr. Aman Hingorani to share his thoughts with us?
Thank you, Tarun. Good evening to all, and thank you all for being here. Now, when I was being introduced, I was told I should share my views on Kashmir. Today's subject is human rights jurisprudence. So I thought I'll speak on when we talk about jurisprudence, the most effective tool as far as India is concerned to protect human rights is Indian PIL. So I was thinking of talking about that to show, or rather share my views of how we need to revisit PIL, given the kind of orders we're getting these days. But since there's a request to talk on Kashmir, I think I'll just spend 2-3 minutes talking on that and then come back to talking on what I really came to talk about on this discussion. As far as Kashmir issue is concerned, the Indian polity equates Kashmir issue with Article 370, it's abrogated it recently, and with cross-border terrorism by Pakistan. I have researched on the Kashmir issue for my doctorate since 1995. And that doctorate, a slice of it is out there in form of the book, which was released by the then Chief Justice of India in 2016. The Kashmir issue is not 370. One can't locate the Kashmir issue in Article 370. The genesis is not there, hence the solution is not there. The Kashmir issue is much more multi-layered, is wider. The princely state of Jammu and Kashmir was a sovereign country as of 15th August 1947, and I don't say that, the Indian Supreme Court says that. The state acceded to India in 1947, and it became an integral part of India. The entire state became an integral part of India and still remains an integral part of India. And accession is an act of state, it binds everybody. Nobody can reopen it. And it exceeded under the very laws that created India and Pakistan. So the very law that made Pakistan makes J&K a part of India. However, having said that, it is New Delhi which accepted the accession provisionally. It is New Delhi which talked about plebiscite. It is New Delhi which internationalized the Kashmir issue. New Delhi which gave a disputed territory tag on J&K. And so, according to me, unless this disputed territory tag, nothing will work in Kashmir. More than 50% of the state, 35% of J&K is lying with Pakistan, 20% is occupied by China. More than 50% of Indian territory is occupied, is under foreign rule. We have disowned our citizens, we have disowned our territory. They don't have any human rights. Nawaz Sharif told the Pakistan Supreme Court, we can't give them human rights, they're not Pakistani citizens. We keep talking about, we have parliament resolutions saying we must get back POK. Unofficial policies, LOC into the international border. We disown our territory, disown our people. According to me, that policy is misconceived. Application of the Bharatiya's case, basic structure, unity and territorial integrity is part of basic structure. SR Gomai, you can't give away Indian territory. But be that as it may, the Kashmir issue is any solution which is premised on the part of J&K with us, the person, whether it is 370, whether it is trying to rehabilitate the Kashmir, but everybody has a different perception of what is the Kashmir issue. For the Kashmiri, it is autonomy. For the Kashmiri Hindus, it is becoming a refugee in their own country, the terrible happenings in 1990, gross violation of human rights. For Jammu and Ladakh, it's uneven development in that former state. For the Indian security forces, it's law and order problem caused by terrorism by Pakistan. Everybody has a different perception, but till you are able to get rid of the disputed territory tag, everybody is speaking to each other in a language nobody understands. And so the book actually talks about why we had partition, why the Kashmir issue was created by the British for their strategic interest, how we messed it up in 1947, how do we undo our, we need to get into the past to be able to find a way forward. And the book pieces it together a kind of a roadmap for New Delhi, how we can resolve this longest standing dispute. So that's all I'll talk about Kashmir. If anybody is really interested in reading it up, the name of the book is Unraveling the Kashmir Knot. The publisher is Sage. So that is what is in just a few minutes I'll touch upon, since that was the request. But coming back to what I really do want to share my views on, which is PIL. You see, the traditional judicial role of any court is adjudication. A has a problem with B, they go to lawyers, there's a conflict, the judge decides that conflict. So there's a decision of the conflict. In adjudication, we have inherited the common law system. So you have this adversarial system where the rules are meant to keep the litigant, the lawyer, and the judge in check. So you got to have the aggrieved person coming to court, that person show the credentials, there has to be pleadings, evidence has to be led. All these requirements are meant to have a level playing field, not only to keep the litigant and the lawyer in check, but also the judge in check. Judge is bound by the pleadings, judge is bound by the issues, judge can't have a very proactive role, judge can't go around interfering with policy decisions, judge can't legislate. The reason being is that here's a conflict that is to be decided. All over the world, whenever we talk about public interest cases within the common law system, you do have things like class action, representative cases. We have that under RCPC, Order 1 Rule 8 CPC. But they are also with the same limitations on the parties and on the judge. The reason being there has to be uniformity, no subjective exercise of power. If we're not on motives here at all, but if power is to be exercised subjectively, it will be exercised arbitrarily. And hence, it is important that there must be some standard, some uniformity, some limitations on the judge, some limitations on litigants and the parties. So, our Supreme Court was within the common law system, within the natural law school and the positive law school was swinging within the common law system right from 1950 to 1979. You may have started with the A.K. Gopalan Positive Law School, came back to Golaknath Natural Law School, going back to Kishan Bharati, midway, coming back to ADM Jabalpur Positive Law School, coming to Maneka Gandhi. All these cases were within the common law system. In all these cases, the court was deciding. There was a conflict, a list, as we call it. The Sharath Hasan, the 12 business case was the first PIL in 1979, AIR 1979 Supreme Court 1360, where, as you all be aware, thousands of prisoners were sitting in jail awaiting trial. They were supposed to be guilty for ticketless travel. He's been picked up for ticketless travel. He should have been there for 6 months at best. He was there for 20 years. Awaiting trial, he had been put in jail. Had they been tried, convicted, given maximum sentence running concurrently, not running consecutively, not concurrently, even then they would be out. People were there who were victims of a crime. So rape victim, no place to go, put her in jail. Because we need her for giving evidence. Ashrams are closed down, children have no place to go, put them in jail. Here there is no conflict. Right to move the Supreme Court to protect a fundamental right is a guaranteed fundamental right itself by Article 32. And so anybody can move the court, tell the court, is your job, please protect the fundamental right. But here the court is not adjudicating, there's nothing to adjudicate. You simply can't keep people in jail for 20 years when the maximum punishment is 6 months. Bhalur blinding's case, 33 suspected criminals blinded by police in police custody using needles and pouring acid in the eyes. You can't do that. There's no conflict. There's nothing for court to decide. Rudol Shah's case. He is arrested in 1953 on the charge of murdering his wife. Session judge says, acquit him, release on further orders. The session judge forgot to write those pass further orders. Rudol Shah was in jail for 14 years after his acquittal, having been found to be innocent. First time the Supreme Court did give compensation under Article 32. Again, no conflict. There's nothing for the court to decide. Mental asylum cases, people being chained naked to beds. No medicine, no food, no water, no doctors, no treatment. One every second day. Again, no conflict. You can't keep it like this. In all these cases, it's not adversarial because there's nothing to decide. And that's why the distinctiveness of Indian PIL, the way it was conceived, the reason why it was conceived was it is the court's duty to protect fundamental rights under Article 32. Appropriate proceedings can be even a telex or telegram. All that a person has to do is to bring it to the notice of the court that this section of people who don't have access to court because of disability, illiteracy, mental illness, whatever may be the reason, but they don't have access to court, please protect the fundamental rights. It's your constitutional obligation under Article 32. It's not important who brings it to the notice of the court, but it's the job of the court to protect fundamental rights. PIL is a remedial jurisprudence enabling the court to protect fundamental rights. And for that purpose, the court can intervene on policy issues. It can get in, so you have crime against women being set up. It can legislate. So you have the sexual harassment of workplace rules coming up. You have the guidelines laid down by the Supreme Court for adoption of Indian children, Lakshmikant Pandey's case, and so on and so forth. So whatever was not in the common law system, the court can't legislate, court can't impinge on policy issues. You can do that because you're not adjudicating. You can have different roles. You'll be the monitor, you're an investigator, you're trying to be a legislator, you're trying to find remedies for the entire system because there's no conflict. In these limited kind of cases, it is okay if the limitations of the common law on judges is released. It's okay if the court applies its own mind to be proactive, because here there's no two sides. Everybody's collaborating, the petitioner, the respondent in the state, and the court. Everybody is collaborating with each other to find a solution. So here, if we relieve the judges from the limitations of the common law system, of being bound by pleadings, bound by issues, being bound by the evidence, it is fine, it's safe. Because there won't be arbitrary excess of power. But if you extend this, as the Indian Supreme Court has done, when it comes to matters that could have been litigated as class action, the diffuse collective rights, if you see the judgment in SP Gupta, and again reviewed the entire line of PL cases reviewed in State of Uttarakhand versus Balwant Singh Chaufal, 2010 Supreme Court judgment, where the court talks about different phases. First phase was for the poor, the marginalized, the destitute, the impoverished. Then the phase 2 was for environment pollution cases. Phase 3 was for judicial probity, rule of law, those kind of matters. Phase 2, phase 3 cases could have been litigated as class actions, complete with the checks and balances and limitations on the judge that he does not exercise his power subjectively. The fallout of all this has happened is that today, PIL, which was conceived for the poor, has been hijacked for middle class interests, smoking, CNG buses, environment pollution. They're important issues, but they could easily have been litigated as class action, complete with the check and balance of common law system, both on the litigant and the judge. But here what has happened is the instrument which was conceived for the poor, that has been blunted. So the PIL meant for those who do not have access to court. The minute you have access, you have a stake in the matter. Environment pollution, we all have a stake in the matter. In rule of law, we all have a stake in the matter. Those kind of cases, if you bring that within PIL, the scope of PIL, which the Indian Supreme Court has done from 1981 onwards, the fallout is that the casualty of all this is the poor. Nobody's going to file cases for them anymore because it does not give publicity. You've blunted the instrument which was unique to India. The fallout of that also is the misuse of PIL by unscrupulous litigants, ulterior motive. You don't want, like an industry, have it closed down, file a PIL. You want publicity, file a PIL. The backlash of that is framing of rules. As laid down by Supreme Court, directed the High Court to frame the rules. High Court framed the rules. Rules talk about credentials of the PIL petitioner, the burden of proof being on the person who's making that fact. That takes away the very spirit of PIL. That is, the first PIL case was based on a press report, one press report. The burden of proof in PIL cases is on the court, it's not on the petitioner. because it's supposed to be remedial. But the rules which are being framed by the high courts have again taken away the flexibility of the innovation of PIL. PIL was not conceived by the courts. Let me set that record straight. It was lawyers who brought PIL to the court, Usra Khatun, Khatri, Babul Brand, etc. And the courts were forced to act because there were such hard cases. Any court in any country would have had to act. But what the innovation of the court was to expand PIL, to expand the scope of judicial review, whether it was to get political power vis-a-vis executive and legislature, institutional tussle, is a different issue. I'm not getting into that right now because that will take more time to discuss. That whether a judicial strategy should have been used, a litigative strategy should have been used by the judiciary to enhance its legitimacy, to fill in a political vacuum, to hijack or creep into the jurisdiction of executive legislature. That's a different issue. But the only point which I'm trying to make today, because we are short of time, only point I want to make today is high time that we retrieve PIL, redefine PIL in such a way that it is used for the people for whom it was conceived. We need to have a revisit. Otherwise, again, it's a question of time. Then when the judges will be citing limits of the law to throw out this entire jurisprudence, which is unique to India. Many countries, many constitutions, South Africa, Philippines, Malaysia, they all tried it. Nowhere has it taken birth the way it has taken in India. It's a very unique innovation, uniquely Indian. A non-common law system, a non-Anglo-Saxon jurisprudence. We need to preserve it, we need to strengthen it. And one way of doing that is revisit certain aspects of it, mainly confine PIL only to those cases which are where there is lack of access to the courts and the person moving the court has actually no stake in the matter. With that, I'll conclude since I see Tarun on the screen. I think it's my 15 minutes up. And then I'll be free, of course, happy to take any question answers.
As always, Aman, it was a pleasure listening to you. And thank you so much for sparing your time and sharing your thoughts with us today. And without wasting any time, because you're already running late, I would like to go to Justice Iqbal Ahmed Ansari, following which we'll also do a round of 1 or 2 questions. But sir, if you could please address the audience gathered on Zoom today, please.
Thank you, Tarun. Good evening, ladies and gentlemen. We are on the human rights, and as we all know, human rights are a bundle of rights which are inalienable and necessary for the purpose of enabling a man or a woman to live with dignity. So whatever right is required for a person to live with dignity is human right. Now, my endeavor in this short session will be to show that as far as human rights are concerned, they do not depend on the mercy of the court or mercy of the state. It is a different matter whether we recognize or we don't recognize. Let me start by giving an example. In UK, the definition of rape was and has largely remained the same. Unlawful sexual intercourse by a man with a woman without her consent or against her will. I am repeating, unlawful sexual intercourse by a man with a woman without her consent or against her will. Now imagine a situation where we did not even know how to clad ourselves. And in that kind of a situation, when a woman was half clad or not clad, somebody made an attempt to outrage her modesty or simply wanted to have sex. Can we say that since there was no Human Rights Protection Act, so there was no human right? The English court decided by saying that by marriage, a woman surrenders herself to her husband, and therefore the word unlawful has to be read outside the institution of marriage. And if it is read outside the institution of marriage, then in that event, the husband cannot be held liable for committing rape on his wife if he has sex with her without her consent or against her will. Sometime later, the same question came up before the court, but the society had by then changed quite a lot. The perception of the society had changed, the outlook of the society had changed. So the court said that gone are those days when man and woman were not equal. Today they are equal partners in the institution of marriage, and there is no reason therefore to read the expression unlawful outside the institution of marriage. And if you read it within the institution of marriage, then it will mean that if a husband has sex with his wife without her consent or against her will, it will amount to rape. So you will see, ladies and gentlemen, that there is no change in the definition of law. The definition has remained, but the perception having changed, concept having changed, outlook having changed, the meaning of the law has changed. We can't say when the first decision was given that no rape is committed by a husband when he has sex forcibly with his wife, there was no violation of human rights. And it is only with the second judgment when the court held that yes, the husband will also be held responsible for committing rape, that it's a violation of human right. No, it's a matter of recognition of that right. So we must bear in mind that human right is a right which requires recognition, not that it is a right which is created for the first time. It's only to be recognized. No wonder, therefore, that we have in India the enactment which is known as Protection of Human Rights Act. The rights are already there, they are required to be protected. Now, one of the means of preserving these rights or protecting these rights is a set of principles of natural justice. I'll give you one example. Sometime back, a staffer of the Supreme Court brought an allegation against the then Chief Justice of India, making accusation of his making advances against her. The case was listed on a holiday before a three-judge bench, which had the Chief Justice himself. And the Chief Justice started making observation, and this is important for us to understand human rights, that this is being done for damaging the institution of judiciary. Now imagine a woman is being condemned without being heard. This is the principle of natural justice that we say nobody should be condemned without being heard. Now when it is done, what it leads to is not only violation of the principle of natural justice, but it is denial of human right, because you are condemning a woman as a liar by resorting to what I have just indicated. And then, as they say that no one can be a judge in his own cause, the Chief Justice of India himself said there, it is a different matter that he did not sign the order and therefore says that he was not a signatory to the judgment. At the same time, he has now said that, well, it is not necessary for every judge to sign. What does it mean? So this is the way. The third important aspect of the law is, which Mr. Hingorani was trying to indicate, is the rule of law. Because if there is no rule of law, there will be denial of human rights. I think many of you will recall that in Iqbal's case, the Supreme Court referred to a judgment of UK, that is Bishop of Rochester. In that particular case, the punishment prescribed was that the guilty will be thrown into boiling oil. But what they wanted to say was, and the Supreme Court upheld it, unfortunately, that it is enough to have a law. That means if you have a law, even if it is a barbaric law, the way I've said that throw the man into boiling oil, there is no remedy for the person. But coming into the case of Menka Gandhi, it is for the first time that we said that no, it is not enough to have a law. That law has to be just, fair, and reasonable. This is just, you can say, overtaking the judgment of A.K. Gopalan's case. So that is the principle. Once you have a law, that law has to be just, fair, and reasonable. If the law is not just, fair, and reasonable, then in that event, there will be denial of human rights in the way the denial of human rights I am trying to point out in the case of the staffer of the Supreme Court. Now, another matter which we must bear in mind is that if we have to appreciate the violation of human rights, whether there has been a violation of human rights or not, we'll have to put ourselves in that position. Because it is wisely said that it is the wearer who knows where the shoe pinches. Unless and until we put ourselves in the position in which the woman was, the person concerned was placed.
नहीं अभी एक और चल रहा है, जस्टिस हैं दो हाई कोर्ट के, कोई बात नहीं है, वो चल रहा है.
Hello, hello, hello.
अभी कुछ नहीं है ये अभी.
Tarun, can I speak?
So you must speak, and may I request everyone to please switch off their microphones as well as their video calls, because it leads to disturbance. May I request every participant to please switch off their microphones? Sir, you may please continue.
Okay. I am just trying to conclude by giving one example.
Yes.
That only the facts of the case may take some time, that's all.
Yes.
There was a girl. Girl means about 19-20 years. And this woman suffered from many misfortunes. She was born into a family of very poor parents. The mother was a domestic help, and so far as the father was concerned, he used to go out from the village to nearby township and earn his daily wages. The other problem was that this girl was good to look at. That was also her misfortune. And the third one was that she was completely blind. Now, her younger sister used to take her from place to place, one house to another house in the village or nearby villages, and they used to collect the alms. This was the manner in which. One day, according to this girl, when she was returning with her sister, there was a contractor whose name was Aziz. So that there was a woman who used to live as a domestic help in the house of Aziz. This woman was standing on the gate and she said, "Come inside, I have to give you something." So she goes inside. The woman makes her sit on the floor of the kitchen and goes out with a pitcher to fetch water. And the younger sister of this girl started playing with other girls in the courtyard, which was nearby. And adjacent to the courtyard was the kitchen. After a while, according to this girl, she heard the doors of the kitchen being closed. So she became alert and stood up. She said, "Who is it?" So according to her, somebody, some male voice said in whisper, "Shh, I am Aziz." Right? Then she says that no, he came forward, he caught hold of my hand. I tried to struggle and free myself. I told him that you are a very honorable man, you are a big, great person, you are known to everybody. My life will be ruined, so please leave me. But he overpowered her, gagged her, and subjected her to rape. Thereafter, he left. The children who were playing outside, including the sister of this girl, they started hearing somebody sobbing. So they came running inside and then found this blind girl sobbing. Everybody asked her. She didn't reply. What was the cause? She simply said, "Please take me home to her sister." So she was brought home. When the mother returned in the evening, this girl narrated the incident. Mother waited for the father to come because a decision had to be taken. The man, the contractor, was something who was very influential in that locality. So when the father came, he was informed and he went to the Pradhan of that village and informed him that this is what has happened. Pradhan says, "I find it unbelievable that Aziz will do like this, but even then, since you are making the allegation, I will call him and speak to him." So when the father returned to the Pradhan of the village headman said that no, Aziz says that you have gone mad. Do you think I will ever have anything to do with this blind girl, who was very charming and good looking, as I said? The father went and lodged an FIR. It's perhaps it's very rare that this FIR ultimately led to filing of charge sheet, because obviously there was no medical evidence which could have been gathered. The court found the delay in the lodging of the FIR quite convincing. The question which arose that confronted the court, there are two. One, how could this blind girl know that it was Aziz? It could have been anybody else. And the second one was, why did she shout for help when Aziz or whoever he was trying to forcibly have sex with her? So the first question when she was asked in the court, how did you know it was Aziz? So the girl's prompt reply was, let 10 persons speak in the court. I will tell who is Aziz. Thereafter, obviously, defense had nothing to ask so far as the identity by voice of Aziz was concerned. But the second question was that why she did not shout for help. And this is the mighty question and the question on which I am focusing. So the trial judge in the judgment which he has written has very nicely said that we have to, the person whose rights are violated, we have to place ourselves in that person's position. So when we plant ourselves in the position of a blind girl, we have to start appreciating how, if a person does not see, if he is blind, he will react. If I go to a market and I see my enemy coming, I may run away. But if I am blind, I will not know. I will not be able to run. That is why when the attempt of a girl, particularly in Indian scenario in a village, would be to get out of the situation. And therefore, it would not be unnatural wholly that she would be pleading with a person like Aziz that please leave me because your honor and my honor are at stake. This is the case which is used as a research work in one of the universities in UK, although the case is from India. So, if we have to appreciate the violation of the human rights, as per Mr. Hingorani was trying to say, and in that event, we'll have to place ourselves in that position. And then only we will know how the violation of the human rights was done. I have taken perhaps a little more time than what I ought to have taken. Thank you very much, Tarun, for allowing me to speak. Thank you. Go mute.
Tarun, unmute yourself. Tarun, unmute yourself, please.
I beg your pardon. Justice Ansari, it is always a pleasure listening to you and also have you on my show. You've been someone who has regularly given us time and appeared on the show. And thank you so much for also making time for this webinar. Now, as you were speaking, I saw about 4 people, Praveen, Hina, Ruxana and Darshan. I'm naming again Praveen, Hina, Ruxana and Darshan. They have some questions. For the questions, I'll request Nitesh to allow them to ask these questions and then we can conclude the session. He can hand it over to me for concluding. But Nitesh, could you please come in and ask, help them, all these panelists ask the questions?
Yeah, definitely. Why not?
Yes.
First question is of whom?
Praveen.
Yeah, I'll just. Yes, Parveen, you are unmuted now, so you can ask your question to the panelists. Parveen.
So, am I audible?
Yes, you are.
Yeah, you are.
Yes. So, my question was that if you are talking about human rights, I think it's a very primary concern that it should be that if we are demanding justice or judgment, it should be speedy. But I think speedy does not mean imminent, but it should be in a reasonable period. So, I'm asking that is it which judgment or justice we are getting, is it reasonable, is it within a reasonable period? If it is not in a reasonable period, so what our judicial system or justice delivery system can do to secure a faith of a common man on our justice delivery system? This is my question. Are you getting, sir? Hello.
Sure.
Yes, my question was clear, sir. My
Nitesh,
question
could
was,
you address this question to Aman Hingorani, sir?
Yeah, please.
Yes.
sir, anybody can answer this question because I don't have any idea that which one is the expert of this field. So that's why.
Could you repeat your question to Justice Ansari, please?
Okay.
I just repeat for Parveen. Parveen, may I repeat for you?
Yeah, sir. Yeah, you can.
Yeah. So Parveen, you asked that his primary question is that now primary concern for human rights. So my question is that are the justice or the judgments which are being delivered by the courts are coming within
Reasonable period. Yes.
the reasonable period, and if not, what reforms are possible in the justice delivery system to secure the faith of the common man?
Yes, sir. If not, there is a comma. I'm not mentioned there. I'm saying that if it is not in reasonable period, so what reform we can do in our judicial system or justice delivery system to secure a faith of a common man?
I may add that in one of the judgment, Justice Hidayatullah has said that even court will be responsible for violation of human rights.
Yeah. Sir, which judgment, sir? Which judgment, sir? Can you repeat the judgment?
Yes, का नाम बोलो मैं. Just a minute, I'll be able to give. Let the other questions proceed. I will find out.
Okay, sir. No issue, sir. You can continue. I may search. You can continue that thing without judgment.
Naresh. That is Mirjakar case.
Okay, okay, sir.
See the dissenting judgment of
Okay,
Justice Hidayatullah. There he mentions it.
okay, sir. Thank you, sir.
Sir, can you please repeat once again the case name? I cannot hear.
It's Mir Jada.
Case that is Naresh Sridhar Mirjakar. It's a famous
Thank you, sir.
Mirjakar's case.
Thank you, sir.
In the year 1966.
Good evening, sir.
Yes, Hina. Yes, Hina, you can ask the question.
Yes, sir. Sir, I have two questions. First question is, when we talk about the domestic violence, it also covers sexual abuse. On the other hand, there is marital rape, but there is no such exact section in IPC like for the same only for girls only under 18 years. So can we take sexual abuse as a marital rape, as it's also a violation of human rights? Second question is, in Punjab state, mostly people prefer NRI marriages, but mostly women have to stay their home only on after marriages, as their husbands linger on only on visas. So what are the measures in this matter? Thank you, sir.
As far as the marital rape in India is concerned, we know that so far we do not have any legislation holding that marital rape is illegal. But as I am saying, that human right does not depend on the courtesy of the state. The state may not have recognized it, may not have made it punishable, but nonetheless it will be human rights. If you find that this is something which undermines the dignity of the woman, if it undermines the dignity of the woman, and it is necessary this right to have her right to say no. If this right is a right which should be made available to her, then it's her human right. This is what precisely I am trying to say. Don't confuse by the fact as to whether an act or omission has or has not been made punishable. If the act has the dimensions of violation of human rights, it's a human violation of human rights. Maybe we are not recognizing it today, we'll recognize it sometime later. In India, we have, we all know, a concept of statutory rape, which is not there in UK or US. Here, if the girl is below the age of 18 years, you can't have sex even if she gives consent. If it is 5, it is minimum 16 years. So this is the difference that we have. But there this concept of statutory rape is not there. There is no minimum age prescribed for a woman or a girl to give her consent so far as sex is concerned. And that leads to a lot of differences, in fact, cruel differences. I came across a case, if I'm not making a mistake, in Birmingham, where the gang rape had taken place, in the sense that there were 3 girls and about 7 boys. They had a case, the defense was that we used to have sex with the consent of these girls, and on that day her aunt turned up, and that's why they converted it into a case of rape. Now, the defendant's counsel was the barrister. He asked, did you have sex with the defendant Nathan? Because that was the main defendant. She says, yes. Then the next question was, did you use condom? She says, yes. Then she was asked, what was the make of the condom? Then it went on to what was the color of the condom. Then it went on to say, what was the flavor of the condom? I was aghast because in India we would not. But this is the difference because of the fact that we have a concept of statutory rape. That's why we don't allow any such question. Whereas this kind of a question is permitted and has to be answered by a witness in the trial court in the Western countries. So not that everything that we have in India is bad. One advantage which we have in India, in UK or in the Western countries, is that the witness only appears by a video system as we do on the television, which is controlled by the judge. Whereas in India, we do not have any such system. CRPC has provided now that the accused shall not be visible, right? But I just don't understand if the witness appears, his demeanor is required to be noted in criminal law. And if you keep him completely blocked by the witness, court or the lawyers will know whether she is telling the truth or she is not telling the truth. Thank you.
Nitesh, with regard to second question that was asked, that marriages take place and in Punjab and the
I'll clarify, yes. That
right.
question is that as far as NRIs are concerned, as such, there is a separate commission, there is a separate court which deals with it. Recently, Delhi High Court has dismissed a public interest litigation on this NRI matter which was filed. And there I find Mr. Hingorani's presentation very, very appealing, that it is the court has to ensure that in a public interest litigation, it is not the petitioner who is coming, who has the burden of proof. Burden of proof really rests on the court to find out. It's not burden of proof, I would say the court has the responsibility of determining where lies the truth. So as far as NRIs are concerned, we are not, it does not come to the human rights of the Commission of Punjab, but nonetheless, the cases are coming to us, and wherever we can provide some kind of a remedy or redress to the victim, otherwise we make it over to the commission under the NRI.
Sir, just in 2 words, sir. Just in 2 words, even under Domestic Violence Act, there is a remedy under provisions of Domestic Violence Act and 498 of CPC, of IPC, wherein you can initiate proceedings from your place of domicile, and any judgment and order which is passed by the honorable courts will be honored over there in whichever country. And I think UK is a signatory to the reciprocals, and the orders of Indian courts hold good over there.
May I come in at this moment, since we overshot of time by about 25 minutes or so?
Your link is not working.
Am I audible?
Yes.
Yes.
Since we have overshot our time by about 25 minutes or so, with the consent of our panelists, could we take the last question and thereafter end this session for today, if I have the consent of my panelists?
Please.
Okay, no problem.
So Nitesh, can you please go and ask the last question, following which I'll conclude the session?
Yeah, this is by Ruxana Akhtar.
Yes, sir. Hello.
Yeah.
Am I audible?
Yeah, you can ask your question.
Yes. First of all, I want to thank all the panelists for quite an exhaustive speech. So first of all, I want to ask a question my question is for Aman sir. So I would like you to put light to the recent Supreme Court judgment regarding the access to 4G internet in J&K, citing the precedence of Kerala High Court, where right to internet was counted as a facet under Article 21 of Freedom of Right to Education. So what do you think is the principle of proportionality appropriately used, or is it failing to acknowledge the right to education of the students under the reasonable restriction relating to terrorism factor in J&K?
Well, your question can be answered several levels, has multiple issues, but since you're short of time, I think just a couple of points I would like to make. First of all, no fundamental right is absolute. And be enforced by law on the exercise of those fundamental rights, that's what the Constitution says. The issue really is regarding this particular 4G, the critique which we see in papers and otherwise is more on the fact that it is the right forum to decide, to draw that balance between public safety, on one side you have security of the state, terrorism, etc. On the other side, you have a freedom of speech, expression, and right to the net being there. That balancing act, should that have been done by the court, or should it be left for the committee, the executive? So the critique is that basically that it is the job of the court, the balancing act, to test the legality of the action. While testing it, of course, some judges may, so again, like I go back to the, I tend to get back into academic terms, a positivist or natural law school. To put it very simply, positivist law school says law recognizes the rights, so it can take it away. Natural law school says you're born with those human rights. They're inalienable, nobody can take it away, only law recognizes those rights. So law can't take it away. So every judge, right from the time the Supreme Court, even before that, even before the Federal Court Council, every judge swings in their own way of advocating. So I'm not on the issue whether a judge would have said that restrictions are reasonable or not. I depend on the mindset of the judge, the conditioning of the judge, and whether it should have been a judicial mind which decides that balance between public security of the state versus freedom of speech. That's where I think the main critique is. And but like I say, the question you've asked a question which has several issues all mixed up. So I think I would just stop at that. And so that if anybody else wants to add to that, they can of course do so.
Thank you so much, Aman. I would like to thank our panelists, Senior Advocate K.K. Manan, Dr. Aman Hingorani, Justice Iqbal Ahmed Ansari, for being kind enough to stay on, because the session actually extended by 25 minutes. They were patient with us. They also answered questions of all the participants today. So I can't thank them enough for their time. If this was not a Zoom panel, bills were in order to be raised, but I'm sure they'll be kind to us. But thank you all so very much for participating. I would also like to thank Nitesh and Rubinder Ghumman for helping organize this. With their permission, and with my panelists' permission, can we conclude today's show?
Yes, Tarun sir.
Certainly, and Tarun, thank you so much for hosting, for moderating the show. It's always been a pleasure to be associated with you in every manner. Thank you so very much.
My pleasure. I think Senior Advocate K.K. Manan wanted to say a word.
No, I don't want to say anything. That I said that thank you very much for today.
Thank you. Thank you. Thank you so much.
He has the last word. Sir, K.K. Manan has the last word.
Thank you.
He is thanking on our behalf as a host for all.
Yes.